Good evening. Good evening, everybody. We're going to give it just a couple minutes to get started. Welcome. Thanks for joining us this Tuesday night. Thank you for being on time. We always appreciate that. You guys are actually early. That's even nicer. Welcome, welcome, welcome. Have some names of people that I know. It's always nice to see y'all, or at least see your name. Thank you for joining us. And Gilbert, I'm going to go ahead and activate you as interpreter. Thank you for being here. Welcome, everybody. Going to give it just a couple minutes as we have people logging on. Thanks for joining us tonight. I saw Candy. Good evening, everyone. Hope everyone is staying warm. Yes, it is chilly and we're supposed to get more rain. We have a question from Adela. Will you be going over the pros and cons of conservatorship? And not in this particular presentation. That would be probably more for an attorney, and we could talk about supported decision making. This presentation is going to be more about what to expect from the conservatorship investigators. So it's kind of once you're in the process, how that process is going. One of the things that we hear from families is confusion over the process and a little bit of fear when they hear that an investigator is going to be assigned to the case. So we're going to be looking at it from that point of view. Okay, I think we're slowing down, so we're going to go ahead and get started. And I know we'll have more people join us, but good evening, everybody. My name is Beth Burt. I am the Executive Director for the Autism Society here in the Inland Empire and a proud parent of two young men, one of whom has autism, who is now 30. As I was saying, and thank you, Candy, we do have a lot of questions from families about conservatorship, but also about the investigation process of conservatorship. And Brian Herritt, who I've had the privilege of knowing for, we'll just say a long time, is here to talk to us tonight about that. Brian is an amazing presenter. Brian is also who we call the Autism Cop, but he comes with a wealth of information and background. So I know you're going to enjoy the presentation tonight. So I'm going to turn it over to you, Brian, and thank you so much.
Are you going to pull up my PowerPoint for me, Beth, so I can operate it? Or do you need to do that on my own?
Yeah, I would have you do it on your own because that way you can actually share, if you share the screen, because then you can control it. If I
should have asked you before that. I have it, but hold on, let me find out where it is. I apologize. I should have asked you that question prior to doing this. Hold on, let me see if I have it on my screen in front of me. If not, I'll have to go grab my flash drive real quick, and I apologize for that.
All right.
I do have it. Okay, hold on. Let me see if I can make this work.
Yeah.
Sorry, everybody.
That's all right. While Brian's adjusting on the fly, make sure I forgot to mention if you have any questions, throw them in the chat and we'll try to answer them at the end. We are going to be ending at 7:30. We are recording this, so we will also be sending this out and putting it up on our website, so you can always review it in the future.
I'm good, Beth. Hold on, let me pull it up real quick. I got it.
There he goes.
There we go. Does that look familiar?
Yep, and then.
All righty. All right. So thank you, Beth. So for those of you in the audience, my name is Brian Herritt. I am involved with probate conservatorships in my professional capacity. However, to keep things clean, in the event that you are from that area, I'm not putting out exactly what I do and where I do it, but I do have a wealth of experience and hands-on current experience in dealing with conservatorships and guardianship matters in probate court. So if you do have questions, I know there were questions about, hey, the pros and cons. We will be getting into what the investigation consists of and some tips for you guys, but I also go over the kind of highlight the overall of what conservatorship is and the steps to get through there. So hopefully to put some minds at ease, if this is something you're contemplating or something that you have done, or, you know, I do think hopefully it'll be informative to you on a wider scale too of what conservatorship is. So as we get started, and I'm going to minimize so I don't see myself. So conservatorship cases are heard in probate court, and every county has obviously their court systems, and in that court system, it's probate court where conservatorship cases are heard, and it's by judges that are probate assigned judges that handle those cases. I will tell you, Riverside and San Bernardino County, which is what our Inland Empire is, they are very similar as to how they operate those cases and the investigations that are conducted. I have firsthand knowledge of both, and they are relatively similar. There may be some slight differences, but they're relatively similar. The laws and regulations are found in the California Probate Code. So the probate code actually is a very big code, but in there, a lot of things that we're going to talk about today, as far as with the investigation and things that are done, are mandated in that code. So if it's mandated in the code, it's not an option. It's not something that a county cannot do. It's something that's mandated that you have to do. But the probate code is where those where all of the laws that pertain to conservatorships are found. I will tell you, when I said on here, what do you think of when you think about conservatorships? Conservatorships have been around for a long time. They have evolved and changed through time. And right now, actually, because of the Britney Spears conservatorship, that kind of led to a lot of different legislation that is proposed. Some of it has been passed, but passed meaning that they are new regulations, but they are based upon funding for conservatorship investigators and probate court. So, and what I'm referring to is, because of the Britney Spears incident, triggered some California law that added some new provisions to the probate code that we'll talk about a little bit later, but it allows for more investigation, more in-depth investigation, reaching out to more family members and things like that. But the way that the new codes were written, it says that it's based upon funding. So if the court doesn't have funding out of their own budget to fund those additions, they're not required to enact them. And I know this is an issue for some parents, because they'll see on the news, hey, you know, I saw that this new law was passed that says, you know, we have to do a review, say 6 months after, instead of an annual or a biannual. That's true. That is a law. However, it's one of those laws that is dependent upon funding. And a lot of laws were passed in regards to conservatorship, but there was no wide sweeping funding. What they basically said to the courts was, if you have a budget that can cover these things, we would love for you basically to add them. But if you don't have a budget, you're not being forced to add them. So just know that when you hear things on the news about conservatorship changes and the revamp of conservatorship, And I'll even get into some of the specifics into that here in a couple of moments. So what is a conservatorship? I'm sure some of you may already have a conservatorship. Some of you may be looking at a conservatorship, and we'll talk about when to look.
It looks like Brian froze for just a second and lost connection, so he will pop right back on. So yes, I keep putting your questions in the chat and we'll get them answered. Candy had asked about the, it was perfect timing about the new laws and how that's going to impact conservatorship. So he was right on time, Candy, answering your questions. So hopefully he will pop right back in. Does anybody have any other questions they want to throw in the chat? Yes, so we lost Brian. Brian will be back in just a minute, I'm sure. What age can conservatorship start? Good question. We'll make sure we get Brian to answer that. And anything else? I mean, Brian is a wealth of knowledge. There he is. Brian is a wealth of knowledge, so we will use him. There you are, sir.
Where did I leave off?
You were just talking about that there's no funding.
Okay, good.
Yeah.
Okay, then I know where I'm at. All right, guys. Sorry, guys. I never have problems with my internet, but I am having it today for whatever reason. So we're gonna get through it. If I get logged off again, don't worry, guys. I will log right back on and we'll get through it one way or the other. I apologize emphatically. Again, with the funding, and I think this is Beth. Is this where I left off? You're
Yep.
muted, Beth. Okay,
Yep.
cool. No?
Yeah. Yes.
Okay, cool. So basically, I told you guys there are some legal changes that you may hear about in the media, but without funding, the courts aren't required to do them. So now we get into what is a conservatorship. So it occurs on an adult. I saw one of the questions that popped up is if somebody was 15, should we start it now? I would say my advice would probably be you have some time to wait a little bit. You know, normally most courts won't even accept it unless they're 17, maybe 17 and a half. But at 17 and a half, I would look at doing it because, and we'll talk about it in a minute, but depending on like your school district or your doctors or medical care, the day somebody turns 18, by law, they technically could say you need to have a conservatorship if you're going to act on their behalf. So we like to try to get them done maybe a month before they're 18 or right around there. So you have letters in hand and you have a completed conservatorship and it's been granted by their 18th birthday. So it is a legal proceeding in which the court as a whole evaluates the need for a conservatorship. And we'll get into what those are. And that's a big part of that is that investigation of what a court investigator does. But that's what a conservatorship is. So it's an adult who would be unable to take care of their basic needs and they need somebody to help them. Have I ever seen a case where somebody applied for conservatorship and conservatorship wasn't necessary? Yes, I have seen those cases. There are few. I will tell you, in Riverside and San Bernardino Court for conservatorship cases, probably a high percentage of them are people with developmental disabilities that are turning 18, and as part of that process are going through the conservatorship hearing, or going through the conservatorship process. The biggest population of conservatorship cases is on adults with developmental disabilities, is what the majority is. So, and we'll talk about some of that. Is conservatorship, does it apply to somebody with mental illness? It does. It's a different type of conservatorship, and we'll talk about that as we get further into this. But that's what conservatorship as a whole, it's, you got to be an adult. They have to have they have to show that they're unable to take care of any of the things listed, their needs for shelter, food, medical care, manage their personal finances, or be subject to undue influence. Subject to undue influence means that they can be taken advantage of, basically, and they do not understand how to protect themselves from somebody trying to take advantage of them in one way or the other. Who can be a conservator? A conservator is usually a family member or close friend. It is the responsibility of the conservator to ensure the safety and well-being of the adult who cannot care for himself. If there is no one willing to act as a conservator, a private professional conservator or the public guardian may be appointed. Generally, in Riverside, San Bernardino County, those are the cases that get handed off to the public guardian. And that is a county agency that deals with people who need a conservatorship and don't have a family member to do it. We see a lot of public guardian cases in the elderly who have Alzheimer's, who either there is no more living relatives, their children cannot, for whatever reason, take care of them. That's generally where we see the public guardian become involved. For most of them, like I said, the majority of the cases are developmentally delayed adults. And most of them have family members and people they live with. It can be a mom, dad, it can be a brother, sister, it can even be a close friend. It really just kind of deals with the investigation, which is what we're going to talk about. And is that person, through the eyes of the investigator and then through the court, do they have the knowledge and the ability to take care of that person? And there's obviously some different factors that go into it. But, and we'll get into what we look for in conservators and what is looked upon in the investigation of a conservatorship to give you guys some ideas on who may be a good or not good conservator. But it's typically a family member or close friend. And like I said, if there is nobody that can take care of them, those cases are referred to the public guardian, and then they will step in and become the conservator and basically kind of fill that role for a person who doesn't have family to help them take care of themselves. So there are three types of conservatorships. There's general conservatorships, there's limited conservatorships, and then there's LPS conservatorships. So, and I think let me look ahead. Yeah, I break them down. So a general conservatorship is for all other adults who are unable to provide for their personal needs due to physical injury, dementia, or other reasons, rendering them incapable of caring for themselves or making themselves subject to undue influence. So we're going to see in a minute with limited conservatorships are designed for people with diagnosed developmental disabilities. So that's kind of the population of the people we're talking about with autism or with developmental disabilities. A general probate conservatorship is usually used for somebody who maybe gets in a car crash, dementia, or other issues. Now, that's not saying a person with autism, a family member couldn't file for a general probate conservatorship. But in most cases, if you have a developmental disability and you're applying for a general, and I'll explain the difference on what a limited is. Most of the time the judges will ask, why are we not applying for a limited? Because the limited it's kind of most parents and most loved ones know the language of the least restrictive. And the reason a limited conservatorship was developed is it does provide some options to be the least restrictive type of conservatorship. A general probate conservatorship means you have control over basically everything that person does. And I understand as a parent sitting there saying, well, yeah, Brian, that's what I want for my son who has autism. But when I show you what goes into a limited, you'll understand there's kind of a menu that you can pick and choose from in a limited that shows more of that least restricted. So there's a general, and then there's what we call a limited. And again, limiteds are only for a person who is developmentally disabled. It is this type of conservatorship. The powers of the conservator are limited so that the disabled person may live as independently as possible. So limited conservatorship is what I can't give anybody legal advice, but that's what we typically see filed for developmental disabilities as a limited conservatorship. And again, you'll see the conditions of a limited here in a minute when we get, actually here they are. So on a limited, the reason we call it a limited is there are 7 powers in a limited. And what you could do as a petitioner or as a person that's filing for a conservatorship, you could say you want all 7 of these, or maybe you say I only need 2 or 3. And the reason for that is to allow for the gray area of the least restrictive. So what I mean by that is say, you don't necessarily want to get involved in your child who's about to be an adult, their ability to consent to marriage on behalf of you don't want to say who they can and cannot marry, but you also still want to be in charge of their education and their medical consent and things like that. You would be able to kind of selectively pick which issues you want to cover. One of the more controversial is obviously number 6, which is selecting the conservative social and sexual contacts. That doesn't mean that they get in trouble if they, have a sexual contact you don't like. What it does do though, and really kind of the plain term of this is it allows a conservator, the person in charge, to do things like provide birth control, contraceptives, and different things on behalf of the conservatee, even if they don't wish to have it, is typically where that comes into play. Now, I will tell you, in most cases, especially if you're dealing with somebody with autism who's on the more severe side of the spectrum, which is where it's really appropriate for conservatorship, they usually ask for all 7, and that's fine. But the reason these are specifically designed for people with developmental disabilities, again, is because this is kind of your menu to choose what's the least restrictive. So I hope that makes sense as to what they are. An LPS conservatorship is the Lanterman Petra Short conservatorship, and this is the mental health conservatorship. And these are LPS conservatorships, are mental health conservatorships that are placed upon a person who long-term is unable to take care of themselves and is a danger to themselves. So most people, if you've been around mental health or developmental disabilities, will have heard the Welfare and Institution Code 5150, which there's 3 criteria for law enforcement: danger to themselves, danger to others, or gravely disabled, which will allow them to put a hold on somebody for up to 72 hours to get them mental health care and medication so they can be re-released and no longer fit those same criteria. An LPS conservatorship is kind of the long term of that process isn't working anymore. And people can apply for an LPS conservatorship. I will tell you that in my experience, there have been people that have applied for a limited conservatorship. And then once the investigators get into kind of, the heart of the investigation, if there's a big mental health component, then we may be looking at more of the LPS conservatorship. I will tell you the LPS conservatorships are primarily medical. when a regular conservatorship is not so medical. So LPS, everything in it is protected. It's all HIPAA. There are many extra protections. There are many extra reporting documents. There are many extra people involved. A typical court investigator will not do LPS conservatorship investigations. Those are done through either the public guardian or the Department of Children and Family Services or Adult Protective Services. Those are the ones that will conduct into these along with mental health professionals. So I would say I will give you my opinion. If you're a family who's looking and saying, Brian, you know, or looking at yourself going, I think this is the way to go, I wouldn't let a family member do anything like this without consulting an attorney. With the other matters, like a limited, you could get through it without an attorney. You know, you could represent yourself and do it. But this is one of those cases that I would strongly advise getting an attorney just because of the legal ramifications with an LPS conservatorship. Likewise, if you're going through the process of a conservatorship on your own and you start hearing the judge or a court-appointed attorney or somebody talking about LPS, then that's when I would say you should probably reach out for your own counsel, because there's so many different factors that play into it that I wouldn't want, and even me, I wouldn't do an LPS without an attorney. And I kind of know what I'm talking about. So that's an LPS. There's also conservatorships of the estate. So when you guys would fill out the paperwork for what type of conservatorship you want, there'll be general, there'll be general of the estate, there'll be limited, and there's even limited of the estate. And what the estate is, and the only time you should ever, if you're applying for one or currently have a conservatorship and you're looking for an estate, is if there is an actual estate. So, and what I mean by that is if there's a large, say you have a special needs trust, you're going to need an estate. Say you, there's one of the parents maybe has been deceased or had a payout of a large payout of life insurance or anything like that, or a large amount of money, then you would want to deal with then you would want to file for the estate. It's usually in a trust or a large amount of money. Bond will be required, which means they're going to tell you have to post bond because of and depending on how much money is in the estate, and court will manage the accounting on that. This is another issue with, if you're dealing with an estate, I would say you're doing an injustice to yourself if you don't hire an attorney. The court will probably appoint an attorney on behalf of your loved one that you're doing. And they also may appoint what they call a guardian ad litem, but they will definitely probably appoint what they call a court-appointed attorney or court-appointed counsel, a CAC. But if you're dealing with the estate and you have a rather large amount of money or anything of an estate, I would say my advice would be don't go into that without an attorney, because you have a lot to lose, and you want to make sure that your dots are dotted and your T's are crossed. But that's what conservatorship of the estate is. What are the steps to filing for conservatorship? And I can tell you for sure, this is San Bernardino. Riverside is pretty similar. I didn't pull their specific info, but I know with San Bernardino. Number one is to gather all the information that you'll need to fill out your forms. And by the end of this, if you're taking notes, you should, and I think best recording it, but you should have a general idea of what's going to be looked at of this. Filling out your forms, being 100% honest with you, you know, it's the kind of thing where people say, Brian, do I need an attorney? Should I get an attorney? Should I not? I would always tell people in issues of your children, if you can afford an attorney and it's not going to ruin you to do it, I would say do it. Can you do it on your own? Absolutely, you can. But you have to fill out your forms. So what you would do first is gather all the information. You'll either, most of it you can do online now, is reach out, go on the probate website for San Bernardino or Riverside Court, type in guardianship, it'll be under probate, and they have packets that you can download, or you can go to court and ask them, of all the forms, and there's a checklist that they all have that you can fill out to fill out your forms. Riverside currently has e-file for probate, San Bernardino is currently working on it. So San Bernardino currently, you would have to drop off your forms after you fill them out at the San Bernardino Justice Center for right now. The main courthouse would be where you would have to drop them off. Riverside, I know, because I filed my conservatorship for my son in Riverside, you can do through e-file. So you'll get all of the forms, you'll fill out the forms, and then you're going to file your forms. Like I said, for Riverside, you're going to do e-file, or you can do them in person. When I did it, was at the height of COVID, and there wasn't an option of going to court. Everything was done remotely. If it's San Bernardino, you're going to file your forms. When you file your forms, you're going to get a hearing date for your conservatorship, and it's usually going to be, it's supposed to be by the probate code within 10 court days of the day you file it. Now, there's some exceptions to that, but they're going to give you a court date, a hearing date, and they're also going to give you a case number when you submit your forms. You want to keep that case number, and you definitely want to go to your court date. When you go, you get the hearing date, you get your case number, you're going to have to serve parties that are part of that case. And what that means is we call it giving notice. And there's a list, again, in your paperwork, they're going to tell you who you have to do it to, but you have to give them notice of the hearings. And what you do by giving notice is you, if it's somebody, you have to get somebody to serve people, and it can be a friend, a family member, anybody, to hand them a piece of paper and sign the form saying, I serve so-and-so. Some of them, depending on the court, and it'll be in your paperwork, can be you can serve them. Some of them cannot be you, but you need to provide proof that you served those people of the court date. Now, that doesn't mean that you get that hearing date in 10 days and everybody has to know about that first hearing. Generally, you could start working on it when you go to that first hearing. They'll give you your next hearing, and by that next hearing is when you want to give service. I would tell you, if you can do it for that first hearing, that's what you want to do. But you're going to have to give notice to both parents, any siblings over the age of 18. You're going to have to give it to first level relatives. And it may be step parent or step brother, step sister, but it's going to give you the list of who you need to notice. I will tell you, if you can't get a hold of somebody, there's a form called a due diligence form that says you've done everything you can do. That's the form that you want if you can't. I will also tell you, and we've run into it pretty frequently, where somebody's in prison. There is a way to serve people in prison. And I'll get to this later. I'm also going to tell you now, both courts have free legal aid. And if you're not hiring an attorney, I would tell you 100% reach out to them, find out where they're at. And the issue of service is one, and notice is one that I would definitely reach out to them, because they know that process and will help you for free. Step 6 is attend a proposed conservator training class. These classes are done online for both Riverside and San Bernardino County. You have to show the court proof that you attended the online conservatorship orientation class. So when you're done with it, you can either take a picture on your phone, you can print it out, you can submit it again through Riverside, you can do it on e-file. San Bernardino, you're going to have to do it in person, or if you're going to court and you have proof, you can just bring any of this stuff that's done. You can bring it to your next court appearance and submit it there. The next step is show up for that first hearing. At some point, whenever the judge is satisfied, you will hear them say, I'm going to refer your case to the court investigator. In your paperwork, you will see a form that says a report for the court investigator. And in that report, you're going to put names and date of birth and stuff like that. That is the form that goes to the court investigator as to start your investigation. When that case gets referred to the court investigator, that's usually between that first appearance and that second appearance. And it gives the court investigator time to do their investigation. Now, probate, we have to get a report done by that second hearing. Investigators don't really have a choice. If we can't, or if they can't, they have to provide a reason to the judge to ask for a continuance. But I will tell you, both courts are really good about getting them in on time. It's a rarity that it doesn't. That investigation is forwarded on to the judge. And what I tell people court investigators do is we're the fact finding for the judge. So the judge will see you at your first hearing. The judge will read your report from the court investigator for your second hearing. And then based on the reports that we'll talk about that are supplied to the judge, that's what they use for the basis to make the decision to grant or not grant a conservatorship. If everything is done at your second hearing and it's granted, you will receive what we refer to as letters. And letters are basically the piece of paperwork you need to show that you have conservatorship over that person. It's one form that says you have conservatorship. And then the final step is after a conservatorship is granted by state law, it's in the probate code, there has to be an annual review 1 year after the granting of the conservatorship. And then after that, every 2 years on the anniversary date, there is supposed to be a review done. And we'll talk about what those reviews are. But those are requirements. So for those that have a conservatorship, now with COVID, San Bernardino Court fell behind, so did Riverside. So they were behind on getting these done. But every year, the year after the first one, and then every 2 years, you should hear from a court investigator saying it's time to do the review. So what does the court investigator do, which is the heart of what this is? What an investigator does is, and who are the investigators? They're not police officers. They're not sworn cops. Investigators come from a lot of different backgrounds. Some come from social services where they work for Children and Family Services. Some come from the regional center. Some come from law enforcement. It's really kind of a hodgepodge of different people. But the investigation itself that they do, it comprises of several factors, and these 5 are kind of the big 5. Number 1 is what we call the capacity declaration. This is going to be in that paperwork, and this is critical for a court investigator, because what a capacity declaration is you have to take paperwork to your loved one's treating physician, and they are going to indicate on that form that in their professional medical opinion, that a conservatorship needs to occur. Now, what it's asking the doctor is this person suffering from a condition that is likely not going to drastically improve, at least not in a reasonable amount of time, and that they are in need for people to help them make decisions on their behalf. Doctors know what capacity declarations are. I will tell you, without that form, things are very tough for a court investigator. And it's very rare for a judge to sign off on one without getting a capacity declaration. So when you do get your forms, that's one of those things you want to set an appointment with your doctor. You want to drop off the paperwork, make sure you have it, make sure it's submitted, read it first so you know what you're dealing with. But that's a capacity declaration. The other part of it is Inland Regional Center. The Inland Regional Center submits reports to the court. The court investigator also will reach out if we don't have one, but when they get filed, the court investigator can see an entire case file. And in there, if there are regional center reports, we will contact their CSC from the regional center. And we will also look at that report and make sure that within that report that it kind of matches the capacity declaration and it kind of validates the need for a conservatorship. We also will look at school reports and IEPs. We have to do an in-person interview with the proposed conservatee. So regardless of the condition or the specific of the level of disability, we have to do an in-person interview by law, by that probate code. And there are certain things that we have to notify that person of. So for me, my son has severe autism. He's nonverbal. But the court investigator, when they come out to do my son's reviews and when they did his petition, they have to advise him, hey, Brian, are you aware that you're under a petition for a conservatorship? Do you know that you're under? And even if they can't respond, by law, they have to ask the question. And it's something that's marked off in their report, and they have to do an in-person interview, which means they're going to have to come to your house. And we are going to look around. To what degree? It's kind of up to each individual investigator. What we're asked to do by the court is to make sure their living quarters is safe and make sure that they have, that it's an appropriate living condition. And we will look into that. And then we also will do phone interviews, but they can interview you as a proposed conservator on the phone, but they have to interview the conservatee in person. In the investigation, again, we're required to do them. We are required to visit the home. We also get and will look into the criminal background of all adults that are living with a conservatee. Now, does that mean if you or somebody, maybe another parent, a brother, somebody has a criminal background or committed a crime, that you're not going to get your conservatorship? No, it doesn't mean that at all. I will tell you, on a routine basis, people have made mistakes. They've accounted for them. They've done what they've done, and they still can be granted conservatorships. I will be honest, though, for investigators, what matters is, are you upfront and honest about it? Because if you're deceptive, that can be something that will affect you in a negative manner. So if you do have a criminal background, the investigator will maybe ask you, hey, have you ever been arrested? Has anybody in your house ever been arrested? And if it's true, just tell them the truth. Yeah, I have been. People make mistakes, and investigators know that, and people can be held accountable for it, and that's fine too. But if you're not, I will guarantee you the worst thing you can do is lie about it or not tell the truth. And I'm being 100% honest with you when I say that. But they will get the criminal background. They will check into it. The other thing you can't do, and this has come up in my experience, where say an adult brother is 30, he was in prison for a while, got out, now he's living at the home. Mom doesn't put him on the paperwork as living there, but the investigator comes to the house and he's there. They ask questions, they realize he's living there. Now we find out that he has a criminal record. That's going to go against the parent for not being upfront about that. So it's really important that you be upfront. But yes, we are going to look into everybody's criminal background. It's what we do. And we have answers to that information. And unfortunately, I'm going to be honest with you, your criminal history will be part of the report. Now, there's two parts to these investigative reports. There's a part to the report, which is the general investigation. And then there's the medical part that includes that capacity declaration. And that's what we call a confidential document. So that's not a document, it's protected under HIPAA. And that's where that criminal history stuff goes. So it's not something that can be accessed by anybody. Nobody else is ever going to see it. It's protected. It's protected by the court. And they do that on purpose because we want families to be honest if they're going to disclose any criminal behavior, and it's not shared and it's not necessarily read in open court. Court investigators they make a recommendation to the judge. We don't make the decision. So what we do at the end of our investigation of talking to everybody, pulling all these reports, doing what we need to do, we make a recommendation to the judge of, hey, we believe that this petition for conservatorship should be granted and is warranted, or we do not believe it's granted and warranted. That happens, but it doesn't happen a ton, I'll be honest. Probably, I don't know, I would say 95% of them are granted. Very seldomly are they not. And hopefully, I think in my case, or at least the people I answer to or that answer to me, you will know ahead of time if that's coming. You'll get the general idea, or we'll flat out tell you we have some concerns. You will get a copy of every report. We like to give it to you a week before you go to court, but in a lot of cases, we're so backed up that you're not going to get it until maybe you won't get it at all. You'll show up at court and then it'll get mailed to you later. If you disagree with anything, either in the report or anything, feel free to speak up and discuss it at the hearing. Don't just, there are mistakes made, and there are times that other people need to get involved. But if you disagree, you have a voice, and I would encourage you as parents or family members to use that voice. with the reviews I talked about, how a review works, again, after a petition has been granted, it's an annual 12-month review. At that point or around that point of the year, they are going to reach out to you. They will get a new criminal record check to see if anything's happened since the last granting of the conservatorship. They need to be in person to come out again. They're going to have to advise the conservatee, who's the person with the conservatorship, or who it's over. They're going to have to advise them of everything. And then they're going to basically, it's just an update on information. So, hey, did you move? Did anybody new move into your house? How are they doing? The court wants to know in a review, and where these reviews go is they go to the judge who's assigned that conservatorship, and they read every one of them. And what they're looking for is, hey, is there anything, because the court is ultimately responsible for that conservatorship, is there anything the investigator found or that mom and dad are talking about that we need to discuss in court? The reviews don't generally call for a court appearance. The investigator will come out, they'll file the report. The only time there's an appearance is if there's an issue, and it's not always a bad issue. The judge can ask for an appearance, and sometimes the court investigator can suggest to the judge, you may want to call an appearance because I'm either having difficulty getting a hold of them or something. But normally these reviews, you don't have to go to court. If you do get a notice to go to court, doesn't mean anything's horribly wrong. It just means the judge wants to talk to you about something. So you would have to go out, but generally, as long as there's no major changes, you're good to go. Some tips or things that I want to throw out to you guys. One is co-conservators. So if you are mom and dad of a 17-and-a-half-year-old who has autism and you're filing for a conservatorship, both of you should file as co-conservators. The reason for that is, and I see this a lot, where just one parent will say, well, I'm the parent that has IHSS, my husband works, I take care of him, so I applied. Well, the problem is that if you as the conservator, something happens to you, now you're at a point where there is nobody legally responsible. Although they're the parent, they don't have conservatorship. Now, I will tell you, if that's the case, nobody's going to show up to your house if something were, you know, and I'm not hoping it does, but if something was to happen, nobody's going to show up to your house and say, hey, we want your kid. But what I'm telling you is the smart way is to always have a co-conservator. Now, if you're a single parent and they have an adult brother or sister who you know is responsible, think of considering them to be a co-conservator. But single conservators, I get it and they happen. But if you do have another person, I'm just telling you, it's in the best interest of that person, if it's somebody you trust, to do that. A successor conservatorship. So say, you know, me and my wife and I have a 22-year-old son, and I have a 13-year-old daughter. So say, 20 years from now, me and my wife are getting older, and I'm not as handsome as I am now because I got more wrinkles. It may be a point where we say, okay, we want to file for co-conservators as a successor to allow my daughter and son to now also be conservators. So if me and my wife can't take care of him anymore, it's already in place for the successor conservatorship to happen. So that's what a successor conservatorship is. So just a tip to think of. So other tips is to start early. Again, 17 and a half is appropriate. I always tell people, if you can afford legal counsel, do it. How much do conservatorships cost? It really depends. I can't give you a cost. I don't know. I know a lot of attorneys. I will tell you, I know Beth at the Autism Society, they have a list, and I'm getting them more of attorneys that are part of their registry that you can reach out to. It doesn't mean they don't endorse them. They're just saying, hey, here's some people that do them. But you can always, reach out to an attorney if that's eligible for you. If not, kind of a step down from that is to go to a legal document assistant. And that's it's not an attorney, but it's a person that knows how to process the paperwork. And they, for a small fee or for a fee, will file your paperwork for you. And if you look up legal document assistant, Riverside County probate, you'll find a list of them. Same thing with San Bernardino. And then lastly, the free aid in San Bernardino, it's on the 10th floor, is our free legal aid. Riverside, I know they have it as well at different locations. you're not wrong for wanting to go there and use those free aids. That's why they're there. Be honest is a really good tip. You know, if somebody's coming to your house and you have some concerns with them coming, I know for me, with my son, I would tell somebody if an investigator called and said, we're going to come to your house, I tell them, you know, just so you know, my son, he's severe with autism. He's nonverbal. He doesn't like people being in my home. He may get upset. I just want to let you know. I've also told them, hey, I'll be honest, I've tore up the carpet in my house because I'm in the process of refixing it. And I'm just upfront with stuff. And I, in doing investigations, would love it if people were. Understand that the investigators that are doing these, they know the families they're dealing with. They're not going into it blind. So as long as you're honest with them, they're going into houses every day, 2 to 3 houses. They know what a family with autism or a family with a child with cerebral palsy, they know what that looks like. So you're just be honest. I mean, seriously, be honest. Keep your letters with you. Again, that's the proof that you have it. And then there is my website if I can help you. I know I'm going to stick around for a while, and Beth will read off questions and let me know because I can't multitask that well. And Beth is much better at it than I am. And I'll come out of my share screen in a minute and you guys can ask, or Beth will read through the chat questions. But if you do have a question, my website has my email address on there. The other way to go about it too is Beth is a really good resource, and I'm really busy. So if you get a hold of Beth, I talk to Beth probably once a week on different factors. So if you really need anything from me, you can reach out to Beth, and if Beth can't answer it for you, she can facilitate and get to me quicker than you guys can, because I've learned a long time ago I can't ignore Beth's phone calls or her emails. So I am going to stop sharing my screen and come back out. And Beth, if you can hear me.
I can. I'm laughing at you. You only can't ignore me because I start calling and emailing and texting and bothering you. But thank you.
And you also know my wife, which that helps too.
It does. It absolutely does. All right, we do have a few questions. Do you know the procedures on how to add an additional conservator if you've had conservatorship for many years? You talked a little bit about that being a possibility. What does somebody need to do that?
They would have to go to the court, just like when they filed their original petition, and they're going to file another petition, and it's not necessarily going to open up a whole new investigation. It is a new investigation, but it'll be limited. But what they want to do is just file a petition, and there's a box on there that says co-conservator or additional conservator or successor conservator, and that's what they want to check. I'll let you go. I'm not going to talk. I'm going to let you go through the chat, Beth. I'm not going to do it because I'm looking at them popping up and I don't want to get off track. So
no, that's okay. That's perfect.
You feed them to me. But the answer to the question is to go to the court and get the paperwork to file a petition. And you need to file the petition for a successor or an additional co-conservator.
Okay. If there's a guardianship in place, does it need to be removed before doing a conservatorship?
Guardianship investigations end at the 18th birthday unless there's special circumstances that can extend them to 21. So most guardianship cases dump at the 18th birthday. So when we're talking about a conservatorship that would start at the 18th birthday. So where that one drops off, the other one would take over.
Okay. What type of attorney works with conservatorship?
Probate attorneys. So what I would have them do is Google probate attorney, San Bernardino County or Riverside County. And the reason I tell you do it by county is not all of them practice in both counties. A lot of them do, but some only do Riverside, some only do San Bernardino. But if you type in probate attorney, you'll see that. And then when you look them up, you'll see some do, because probate is also wills and things like that. Some will just do wills, some will do conservatorship, but you'll see that on either on their website or wherever, when you Google them, what pops up, you'll see conservatorship on there.
And we also have a list on our website. If you want to, you could just in the search bar, type in conservatorship, and we've got some resources of attorneys that other families have recommended. If we move, do we have to reapply in a new county or state?
Yes. So states differ from person to person. What my advice would be is if you're going to move is to contact your county And I also tell people, keep the number for your court investigator, because the only person you're ever going to be able to reach if you need to call anybody is going to be your court investigator. And I'm just being 100%. That's another tip, is to keep that card or the name and number for your court investigator. But yes, you need to notify the court. If you can't get hold of your court investigator, you're just going to go to the court and say you need to file a change of address. And then what typically happens is, say you're going from San Bernardino to Riverside County, they will open up a case in Riverside County for you as a conservatorship, and the court will then reach out to our court, or their investigators will reach out to our investigators, and they will share that information. But you do need to notify the court if you change, because if you go through, say a review is done and you don't participate and we can't find you, they will suspend your conservatorship if it's not tracked by the court. So you want to make sure you reach out to the court and say, hey, I'm moving. Now, when you go out of state, some states don't have conservatorship. They just call it either adoption or guardianship. So depending on what state you go to, but yes, you want to let the court know if you're moving out of their venue. More important, I think, than letting us know is let where you're going know first, so you can get what you need in place for them before you get there. So you hit the ground running.
Wow. What if my autistic son is 21? Can I still do conservatorship?
Absolutely. You can always file. Like I said, you got to file the petition. You got to go through the process, and they'll look at different things. But yeah, there is no end age. It's just the start age is 18.
How long does this process usually take?
So I would love to tell you that they're all very quick and very expedient, and there's never any issues, but that's not true. Typically, what you're looking at, if everything is done right and you do everything on your side right, meaning you get all your paperwork in on time, everything, you're looking at probably 90 to 120 days. If you don't get paperwork done and things get continued out because you're not getting stuff done, it really can get stretched out. But if everything is done, then you're looking at 3 to 4 months.
Have you seen any conservatorships taken away since the Britney Spears case and the new regulations? Should we be worried that it can be taken away because of this?
No, and I think when you understand what the regulations are, the only real regulations that are out there, and again, they're not funded, so nobody's doing them yet, but one of them is, instead of a year review, it's a 6-month review. The other part of it is, if it comes out, is they're talking about extending who the court investigator needs to talk to going to the second level relatives. So then we're going to cousins, they'll be going out to grandparents, and those are things that, and I'll be honest, with that, you could have complications. I could go talk to a grandparent that you don't get along with and it doesn't agree with your style of parenting, and they say to me, or say to the court investigator, you know what, Brian, I think she's a horrible parent and this is why, I'm not going to say there's not complications, but there isn't funding for those new things to take effect. But I haven't seen, I'll be honest with you, I don't know of a court that's doing everything that was passed in the new laws because of a lack of funding.
And Brian, I'm going to go out on a limb here, and you can disagree with me, but I know you and I have had some conversations about, there's a difference between individuals with mental health who can take medication and live a very typical life on medication versus our population who have more permanent issues that can't be adjusted by medication. And I think that's one of the things that there's not enough of a distinction made between those two populations.
No, and I agree with you. I think that's why the limited conservatorship is there, and that's the difference between the limited and the LPS. And I think with our population, and I get the fear, especially when, I'll be honest, I know of investigations where we've interviewed or investigators have went out and interviewed a proposed conservatee, and they say, I don't want a conservatorship. I don't want my mom to tell me who I date. I don't want them being in charge of me. And what the investigator looks at is the totality of what they're looking at. So, of course, our kids want independence, but the investigator, and they don't make the decision, they make the recommendation. But, you know, in a totality of an investigation, when you're looking at a capacity declaration, you're looking at the regional center, if an investigator is really doing that, yes, they say that, yes, it's noted, but generally the investigators are looking out for the well-being of that person. And a lot of times our populations think they know what's in their best interest, but they don't know what's in their best interest. And I think that's where a lot of the fear I've heard from families comes from with the Britney Spears thing is, I don't want my, you know, my son who has autism, who, you know, has the mental capacity of a 7 and 8-year-old to tell you as an investigator, I don't want a conservatorship, and then you take it away because of Britney Spears. It's not, that's not, I don't see that coming, because I think it's a totality of an investigation. But they do happen. And I'll be honest, some conservatorship cases, and I didn't put that in there, they say there's a recommendation and we recommend, or an investigator says, I don't know what to do. They, in probate court, they can hold it for trial. And they can literally go to trial and say, okay, now we're going to put your child on the stand. You can, you know, you have that whole trial part. If you get to that, you definitely need an attorney, but that doesn't mean you stop fighting. But like I said, I don't have that worry right now, because even with the Britney Spears stuff, I think there's a lot. I have a little bit of faith in the system because I operate in it and I know the safeguards that are within it.
One last question. Are judges taking away voting rights from certain conservatees?
That's part of it. And it's an individual judge thing. I'll be honest with you. It's a crapshoot. I know judges that'll say, Brian, I hate taking away voting rights, because there's part of that conservatorship investigation where one of the advisements is we have to tell a person, are you aware that you don't have the right to vote? Do you want the right to vote? And some judges are, and I think it's changed a lot. I see more judges leaning toward, we're not going to suspend voting rights. We're going to leave it open if they want to do that. But that is something that can be in there, and it is something that is asked.
Thank you, Brian. This was awesome. As always, I know you have to run, but I just want to thank you for your time. We thank Gilbert for his fabulous interpretation. Thank you all for coming. We appreciate all of you. We're supposed to get some more rain, so stay safe out there. We'll be sending out the recording hopefully tomorrow, and take care, everybody. We appreciate you all. Good night.
Bye.